Hi everyone, I'm attorney Aiden Durham with 180 Law Co. You're watching All Up in Your Business, where today we're gonna go back through some of your comments and answer some of the great questions that you guys leave on my videos. Before we get into that though, if you're new to All Up in Your Business, welcome. Please subscribe if you haven't already. If you stay till the end of this video, we're gonna answer all of your questions, but then at the end of the video, I have a question that I'm going to pose to all of you, and I would love some of your feedback. So if you happen to stick around till the end of the video, there will be a question there for you. And of course, while I am a lawyer, I am not your lawyer. The stuff I talk about in my videos is not a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer who's licensed in your state. Which brings me to our first question. It's funny that you should have the message at the end of the video disclaimer that if a viewer has any questions about any legal matter, they should consult with a lawyer or a professional service provider. When I thought, aren't you that? You are a lawyer, I think. Yes, I am a lawyer. But like I just said, I'm not your lawyer. The video, the disclaimer that I put in every video is important because I need to make it explicitly clear that when I do these videos, when I talk about legal stuff, it is not legal advice. Because when I give legal advice to somebody, that comes with a host of responsibilities and potential issues that could come back to me. So even though I am a lawyer, by you watching this video, you are not engaging my legal services. This is not a legal consultation. This is not legal advice. Okay? Got it? If you want legal advice, you need to consult one-on-one with a lawyer in a setting where it's clear that they are giving you legal advice, some sort of legal consultation. If you would like to consult with me on a legal issue, I'd be happy to do so if I can, depending on licensing and conflicts and all of that stuff, but you can find all my contact info down below. Get in touch with me through my website at 180lawco.com. Hello, can an attorney pretend to be a potential attorney just to obtain your information to help the other party? Is that legal? No, it's not. Lawyers are not supposed to do that. That would be wildly unethical. All licensed attorneys are subject to ethics, rules of professional conduct. These rules vary from state to state. Most states follow the ABA, the American Bar Association's model rules of professional conduct. One of those rules, I'm paraphrasing now, but says we can't lie to third parties, misrepresent who we are in an effort to gain information. I think it kind of just says we can't make false statements or material misrepresentations. But no, if an attorney is pretending to be somebody else to obtain information from the opposing party in a case, that would be very, very unethical. Is it illegal? Are they going to go to jail? I don't think so, but definitely unethical. If you're an artist and you trademark or copyright your name, in this instance, an artist name would be a trademark. You wouldn't copyright an artist name. If you're an artist and you trademark your name and you signed your pieces, would that protect your work? No. Signing your artwork doesn't do anything to protect it. Creative works of art, if you're a painter, if you're an artist and you paint things, as soon as you paint the thing, it's protected by copyrights. Sign it or don't, that doesn't affect whether it's protected. It's already protected by copyrights. And whether you have done a trademark registration for your artist name, that also has no impact on the copyright protection that your work has. Question, can you trademark products? No. You can trademark names of products, a logo, a design that you use on a product. There are some trademarkable elements of products, but products themselves, the simple answer is no. The complicated answer is kind of sometimes it depends. An example of this would be like a Coca-Cola bottle. Coca-Cola has a trademark registration for the trade dress of the bottle, the kind of shape of the bottle, and some more of the visual design elements. So to that extent, I guess you could say the product is trademarked, but it's really not. It's the trade dress that is. If my bank charges for ACH transfers, is that a business expense? Yes, I'm assuming you are asking, is that a deductible business expense, like something you can deduct on your taxes. Yes, as long as the ACH transfers are for business purposes. Like if you're making ACH transfers to your friends or family for non-business reasons, then no, those wouldn't be business expenses. But if they're ACH transfers for business reasons, then yeah, your bank charges, your bank fees and stuff are generally going to be deductible business expenses. What if I don't trademark my name and someone wants to steal my business, trademark my name, and force me to cease and desist? While this could happen, it is not likely to happen. Trademark law, trademark rights ultimately come down to first use in the United States. Who used the trademark in commerce first? Doesn't matter who registered it with the USPTO. Who used it first? So if you have a business name, you don't do a trademark registration, but you're using it. Your business is active, you're using your business name in commerce. Let's say 5 years down the line, some other party steals your business name and registers the trademark. They can't now stop you from using it because you have priority, you have an earlier date of first use. There could potentially, depending on the circumstances, be some wiggle room to an extent with that, but the simple answer is if you have prior use, earlier use, then someone can't swoop in and force you to stop just because they've registered a trademark for your same business name later on. Of course, it makes things complicated, and they could kind of passively force you to cease and desist, let's say maybe monetarily, like if a big company that has an endless budget and lots of expensive lawyers at hand, they could outspend you and essentially force you to shut down. But, just speaking legally with the trademarks, they can't do that. If you have an earlier date of first use, you have priority. Is there a limit on how many business accounts someone can have? Bank accounts, I assume. For example, if I want 3 accounts with 3 different banks, thank you. No, not that I'm aware of. I am 99% sure there's no legal limit. Banks may put some limit on how many accounts one person or one business can open, but that might be a bank-to-bank thing. But you can, in theory, have as many bank accounts at as many banks as you want. I have, for my law practice, I think 7 bank accounts. I don't actively use all of them all the time, but I have 6 or 7 active bank accounts spread over 3 different banks right now, I think. So yeah, 3 different accounts with 3 different banks. You could do that as long as the banks don't have a problem with it. Can an LLC have more than 1 trademark? Yeah, absolutely. And there's no legal limit. The limit does not exist. Yes, yes, it can have more than 1 trademark. Could a person's first name be a strong trademark if unique? Absolutely. Yeah, a person's first name can be a strong trademark. It doesn't really even have to be unique. Think of, celebrities. My favorite celebrity, Britney Spears. She has a trademark registration for her first name, Britney, in connection with, I think, a lot of different stuff, one of which at least is a perfume. I know she has a perfume called Britney. She probably has her trademark Britney registered with a bunch of stuff. Britney is not a unique name, but when we see a trademark with Britney, at least me, and I'm biased, but we associate it with Britney Spears. So it can become unique or distinctive by building up the Britney brand. The name itself doesn't necessarily have to be unique, but yeah, a first name could certainly be a strong trademark. Thank you for this great video. You're welcome. Question. In the beginning, you had mentioned slogans. However, no process was defined. Should that be trademarked in the same process as a company name? So are slogans registered? Are the trademarks for slogans registered in the same process as a company name? Yep. Same process. You submit an application with the USPTO. You identify the trademark, the slogan on the application. You indicate if it's being used currently or if you have an intent to use. If it's current use, you submit a specimen showing how you're using that slogan in connection with the goods or services, and then you go through the evaluation process like you would with any other trademark. All right, that's all for this time around with questions. Like I said, now I've got a question for y'all. Are you guys cool with it if I do mostly videos of this style, the kind of Q&A, going through your comments videos? I do, I previously have mixed them in here and there with my normal content where I focus on a specific topic, but these are so much, frankly, these are so much easier for me to do. It takes a lot less planning. It's more fun. You guys give me the topics to talk about. It's easier. Are you guys okay with that? Can I do that? Or are you gonna revolt and not like me anymore if I might, I'll still do my normal content here and there probably, but I like answering your questions. Can I do that? Is that okay? Will you guys keep coming around? Let me know. Comment down below, please. All right, that's all. Like I said, subscribe if you haven't already. You can find my contact info down in the description if you want to get in touch with me, if you need some actual legal advice. Otherwise, thanks so much for watching. I'm Aiden Durham, and I'll see you next time.